Okay, we're going to take a look at question 5 from July of 2015. It's a corporations and professional responsibility crossover. It's very hard to actually get corporations questions to stand on their own. I did find some, but generally they're crossover partnership, agency, or PR. So feel free to just jump in and do those. Okay, let's take the question from always go to the call to question first. We know how to do essays, hopefully by this point. What are Dick's rights and remedies, if any, against Jane, Sam, and or Harry? So we're going to have Dick versus Jane. We're going to have Dick versus Sam. And Dick versus Harry. Now, right now, we don't know if all of these directors are together, if we should separate them. So I like to separate them at first until I figure out, okay, well, they've all committed the same thing. All right, and what ethical violations, if any, has Harry committed? So here we'll put the PR issue, ethical violations. And Harry, as we know, is a lawyer, which is interesting. They don't call him A, or they don't name Harry with an A or with an L, which they usually do when they talk about attorneys and lawyers. Okay. Online was duly incorporated. When they're saying it's duly incorporated, that means formation is not an issue. You do not. It's a de jure corporation. It meets the statutory formalities. It's the examiner's way of saying we're not testing formation today. Duly incorporated as an internet service provider. It's like American Online, maybe. Its articles of incorporation authorize issuance of 1,000 shares of stock at $1,000 par value. What does that mean, par value? Par value is the minimum price that the shares have to be sold, and the articles of incorporation will determine that. And so when the company sells stock, the minimum price they can obtain per share is $1,000. So if they end up selling the shares or giving them away for anything less than par value, the board of directors, whoever authorized the transaction, is going to be liable for the difference, and that's called watered stock, which we end up getting into. Online initially issued only 550 shares to its shareholders as followed. Dick and Sam each received 200, and Jane received 150. So one of the things I like to do is like to know who the parties are. And by the way, if you haven't read this essay yet, feel free to push pause, read it a few times so you get familiar with the fact pattern so that this discussion makes a little bit more sense. Okay, who are the shareholders? Don't forget, the shareholders are the owners of the company. And this is what I would write on my paper. So we know that Dick, Sam, and Jane. And I don't know if this becomes relevant. Well, I'm just going to write down the numbers that they have. But I know who the shareholders are. They're the owners of the company, Dick, Sam, and Jane. Online's board of directors. And as I know, the board of directors go underneath the shareholders because the shareholders own the company. And that's why Dick is bringing suit against Jane and Sam. He looks like he's suing two of the shareholders, and he's suing Harry. We don't know. So to me, it seems like, okay, maybe these two are going to be somewhat similar, and Harry's going to have a little bit of a different duty, as you'll find out. See, Online's board of directors. So their board of directors composed of Jane, Sam, and Harry. Jane, Sam, Harry. And named Jane as the CEO. And Harry is general counsel. I don't know who Sam is. Looks like he doesn't really have a title. Okay, so we know who the shareholders are. We know who the board of directors are. And when we discuss like fiduciary duties of directors, because the shareholders really don't have fiduciary duties, unless, of course, it's a closed corporation, which it doesn't seem like it is. But the shareholders generally don't owe each other any fiduciary duties. Now, the board of directors, on the other hand, do owe the shareholders fiduciary duties. All right? So we know what's what. And I always suggest having, when people ask, like, how often do I outline? I mean, this is going to be the outline, and it's going to be very brief. I'm not going to go into a lot of detail here. I'm just doing it to kind of organize my thoughts. That's what my outline generally does. I like to know who's who, just what I have in my mind. I can already start seeing the picture develop. As you know, as Dick is suing them, and as Dick's a shareholder, not a board of directors, so lets me know they probably breached the duty to a shareholder. Well, if the shareholder's bringing suit against the board of directors, there's got to be some kind of breach of a fiduciary duty, maybe derivative action, and you'll end up seeing that's exactly where it goes. So just kind of putting this chart together really kind of puts you in the right direction of where you need to be. Okay. Online's business grew substantially in the following months. Still, they were short on cash, which is normal. A lot of companies are short on cash. They take out loans. They use their expenses. They create inventory. They've got a lot of contracts in the process, so they're usually short on cash. It's totally normal. It might be inadequate financing, which would be piercing the corporate veil if they're siphoning funds and there's some kind of injustice being done. But we don't have that fact pattern here. It's just something to think about as you're going through the essay. As a result, instead of paying Jane $10,000 of her salary in cash, looks like they owe her $10,000, they issued her 50 additional shares with the approval of its board of directors. So they're giving Jane an extra 50 shares. So here's where extra 50 shares come in. But they owe her $10,000, but they're giving her $50,000 worth of stock. So right there, it's going to be it's one of the first issues you're going to have to deal with is we don't know exactly how this is going to play out right now. So I'm going to think about this. We're going to talk about the par value and watered stock. So the par value of the shares, they have $1,000 per share times 50 shares. That's $50,000. But they only owe her $10,000. So the board of directors are liable for the $40,000 watered stock because they gave away $50,000 worth of shares for $10,000. And Jane, being the CEO, accepted it, which is not good. It's not acting in the best interest of the corporation. Also, she's going to be liable as a shareholder for getting that additional share. So that's the issue right there. That's the first issue. And if you notice, we'll get in that a little bit. Looking to expand its operations, Online sought to enter in a strategic partnership with LargeCo. Jane had learned about LargeCo through Harry's wife, who Jane knew was the majority shareholder of LargeCo. Okay, so she knows that Harry's wife is the majority shareholder. Okay, well that to me is like Jane's going to be breaching probably the duty of care, because if she lets this go through, she's not exercising care, she's not acting in the best interest of the corporation. Jane directed Harry to negotiate the terms of the transaction with his wife's company? Oh my goodness. Why would she do that? So Harry's negotiating the contract on behalf of them. Harry's clearly going to have a conflict because his wife is on the other side of the transaction. Not good. In the course of Harry's negotiation with his wife's company offered to acquire the assets of Online, to acquire the assets. So if you're acquiring the assets, it looks like you're going to have a sale of substantially all the company. So that's a fundamental corporate change. Sale of substantially all assets. Well, actually, 75% is substantial, but here we're having all. So we have a fundamental corporate change. And before we have a fundamental corporate change, it has to be passed by a resolution of the board of directors. Then they have to give notice to all the shareholders so that the shareholders can vote on it. And if a majority of the shareholders end up voting to approve it, the dissenting shareholders have what's called appraisers' rights, and they're allowed to cash in and sell their stock at a reasonable price because they don't want to go through with the new purpose of the company. That's why it's a fundamental corporate change. Something is changing, and the shareholders like, we don't want to be the dissenting shareholders. If there's a majority vote, the minority shareholders can say, all right, buy us out. We want out now. And that's all right. That's their rights, and that's the only remedy they have if they disagree with the fundamental corporate change. Of course, in order to have the fundamental corporate change, in order to sell all the assets of the company, resolution by the board, give notice to the shareholders, and the shareholders are ultimately the ones who are going to approve it or disapprove it. So I don't exactly know where this stuff's going to go right now, but I have these two issues set up. And if you want to start putting them in your computer, not a bad idea, because you'll end up just like plugging and playing them where they're going to go. Okay. So Jane directed Harry to negotiate. Again, he acquired it, offered to acquire the assets in exchange for a cash buyout of $1 million. Okay. So is $1 million a fair price? I don't know. And that's kind of why the examiners leave it a little bit ambiguous. Well, we end up finding out that it's completely unfair based on what happens later. Harry telephoned Jane and Sam. Jane and Sam agreed with Harry. It seems like Jane and Sam can be put together because Sam doesn't do anything that Jane doesn't do. And you'll see why. And then Harry will be separate. Harry telephoned Jane and Sam. Jane and Sam agreed with Harry that the offer was a good idea. Okay, what are they basing this on? So here's where the business judgment rule and the duty of care come in. We're talking about fiduciary duties. In order to the duty of care, you have to act in the best interest of the corporation. You have to make an informed decision. You can rely on competent professionals. You know, what the duty of care is concerned about is hasty, ill-informed, careless action. And they're saying it's a good idea, but what are they basing that on? I don't see any independent evaluation. I don't see any investment bankers coming in. I mean, they may know the value of their company better than anybody else. And if this is actually not, if this is an actual careful decision that's well thought out, where all the facts are disclosed, I mean, there's nothing here that says that Sam knows that this is Harry's wife's company. And I don't know what Sam's making his, I don't know why Sam thinks it's a good idea. And hey, it may very well be a good idea, but I have no idea what Sam's basing his decision on. And that's what the discussion the examiners want you to get at. And Harry accepted the offer. Okay, well, he accepted the offer, but he doesn't have the power to do that because, again, it's a fundamental corporate change, and you're going to need approval of the shareholders. All right. 2 days after completion of the transaction, Harry's wife announced a joint venture with Teco, which is solely owned by Harry. So you see what Harry's doing. He's clearly entering into a conflict because he's on both sides of the transaction. He's selling Online's assets and essentially ripping off Dick because he's taking Dick's money, because Dick is looks like a 1/3 owner in this now that everyone has 200 shares. He's taking Dick's money, essentially 1/3 of the company, selling it to his wife, and then his wife's merging with Harry's company. So Harry clearly has a conflict and has breached his duty of loyalty. And it's going to be hard to prove that this is fair. So the duty of loyalty means that you enter into a conflict of interest transaction. It means you enter into a transaction with yourself, you have a material financial interest, or with a spouse or close relative. And here, Harry is entering into a decision to sell all the company's assets to his wife's company. And because of that conflict, he's going to be breaching his fiduciary duties unless he can prove that the transaction is fair to the company, unless we get approval by a majority of the shareholders, which we don't have, or a majority of the board of directors without the conflict can vote. So essentially, we're going to need Sam and Jane to approve it. Because it's their money, because it's their money too. The thing is, are they well informed? Do they know that this is his wife's company? I know Jane knows. Harry can't vote, so the two of them, that's what we need to approve it. You need a majority vote of the shareholders, a majority vote of the board of directors, or Harry's going to need to show this is fair to the corporation, which might be a little bit hard to do. Okay, so 2 days after the completion of the transaction, they announced a joint venture. We got that. The joint venture was valued at $10 million. Wow. In its press release, Teco described the joint venture as a remarkable synergy of Largeco's new technology with Teco's large consumer base. Okay, well, how did Largeco get that technology? Maybe they got it from Online, so he's turning a profit off of what Online did. The following week, Dick, who's a shareholder, learned of Largeco's acquisitions of Online assets. An expert in technology matters. I mean, yeah, why didn't you consult Dick before you did any of this? You see where the breach of the fiduciary duties come in? No independent evaluation, no experts looking at the price. I don't know why they thought it was a good idea. He was furious about the price in terms of the acquisition, believing that the value of Online had been seriously underestimated. Okay. So it doesn't seem like the transaction was fair. And call number one, what are Dick's rights and remedies, if any, against Jane, Sari, Harry, and Sam? So he wants to bring suit. He's a shareholder. Look who Dick is. It's a shareholder suing the board of directors. And the reason why is it's not a direct action, it's a derivative action. So he's bringing on behalf of the corporation for breach of a fiduciary duty. So the first thing you want to get into is what kind of a suit Dick's going to end up bringing. And that's going to be a derivative action for a breach of a fiduciary duty. First thing you must do is make a written demand to the corporation to remedy the wrong so they can avoid litigation. But that might be futile in this situation because Jane and Harry probably just ignore it. It doesn't seem like Sam knows anything anyways. Sam, you can pretty much kind of just cross out. He's not really here for many purposes except he makes a decision based on no information whatsoever, so it appears. Recovery and derivative action goes back to the corporation. Of course, the attorney bringing the suit is going to get attorney's fees, and that's generally why derivative actions are brought. So that's what Dick's going to file. He's going to file a shareholder's derivative action on behalf of the corporation because Jan, Sam, and Harry breached their fiduciary duties. Okay, so what violations has the board of directors committed? Well, Jane, Sam, and Harry, all three of them, have undervalued the stock. They've given away the stock at less than its par value. Par value means the minimum price that the stock has to be sold for. And because the stock was sold for, they sold $50,000 worth of stock for $10,000, the entire board of directors is liable for the $40,000 difference, which is called watered stock. And Jane is also personally liable because she is the shareholder who received the windfall, if you will. Okay, moving on with that. Then we have the violations of the duty of care. And here the board of directors approved, they approved this. The entire board, which Harry and Sam, approved the giving the stock to Jane, which is a breach of the duty of care because it wasn't actually in the best interest of the corporation. The board of directors approved the shares, and Jane accepted them below value, so Jane's also on the hook. Another reason why Jane breached her duty of care is by telling Harry to negotiate on behalf of the company with his wife's company. And then the directors failed to inform themselves about the details of the matter. They acted quickly for no reason whatsoever, without any advice about the price, and none of their decisions inquired about the fairness of the transaction. They could have consulted Dick. Sam could have called Dick and go, hey, what do you think about this? Or he could have called an investment banker or some type of person who would know the valuation of the company better. There's also no reason why they would act this swiftly. At times, the directors are going to have to make quick decisions based on the timing of matters. Here, there's no reason why they needed to act so swiftly. It was one phone call, and they're selling off the entire think about that. They're selling off the entire company based on one phone call with the guy who negotiated the sale with his wife. Do you see what's going on there? You see why that's wrong? And the business judgment rule is probably not going to protect them because it's hasty action by an ill-informed board will not be protected. So you can't say they acted on a good faith basis in the best interest of the company on an informed basis. They're wasting company assets. They're selling the corporation for way below the market value, or at least so it appears. So the business judgment rule is not going to save them. Again, they also sold, there's a fundamental corporate change, and even though there was a resolution by the board of directors, or so it seems, they did not give the shareholders notice, which Dick is obviously a shareholder, and Dick did not vote on it, which is his right as a shareholder. It's one of the most important rights a shareholder has is voting rights. Now, in terms of Harry, what did he breach himself? One would be the duty of loyalty. Entered into a conflict of interest transaction. It was an extremely unfair deal for the company, and it favored his wife's company. And because it was a related family member, he's very unlikely to be able to exercise an impartial judgment. Now, in terms of the conflict of interest transaction may be upheld, was there approval by a majority of the board of directors? Well, Sam was not provided with the fact that it was Harry's wife's company. So I find that the approval by the board of directors is going to probably be not a good defense. Approval by majority of the shareholders, again, Dick wasn't even asked to vote about it. And it's hard to figure out if the transaction was fair to the company. So it does seem like Harry breached his duty of loyalty. Now that was the corporation's issues, and the ethical issues is the same thing. there was a conflict of interest because Harry was asked to represent online in negotiations with a company that was mainly owned by his wife. And because that conflict existed and because he has his own financial interest in the matter, he should have disclosed the conflict to the company. And I don't even believe that a reasonable lawyer would have consented like this, because I wouldn't want somebody who's representing my company to negotiate a deal with his wife. I find it too hard to be impartial, and I might find the conflict unconsentable, because the rule is if there's a significant risk that the representation will be materially limited by the lawyer's personal responsibilities or personal interests, then the conflict, there's going to be a conflict or potential conflict. Of course, if a reasonable lawyer would consent, then but if a reasonable lawyer would find it to be consentable, then as long as you let the company know, you let your client know about the conflict, that might be fine. But here it seems like it's unconsentable. I wouldn't personally say that that was a good idea. And the final thing was he entered into a business transaction with the client. Essentially, Harry entered into a business transaction with online. The terms of the deal were not fair, and he should have recorded that someone else from the company negotiated the deal with his wife's company, which he didn't do. So pretty much it just has to do with the conflict of interest, and ancillary matter was the business transaction with the client. By accepting an offer from his wife's company, because he's got a material financial interest in his wife's company. Not only that, and he's got a personal interest in it. So there you go. That's question 5 from July 2015. The issues that were tested had to do with the derivative action brought by a shareholder against the board of directors for breach of a fiduciary duty, selling stock below its par value, which results in the issuance of water stock, and it makes the board of directors and the shareholder personally liable. The duty of care, not in the best interest of the company, not in an informed basis. Business judgment will not protect them because it doesn't seem like they made an educated decision, and they did it so swiftly. Harry had a conflict of interest, and that conflict is probably not going to be upheld because it's hard to say that it was fair, and we didn't have all the material facts disclosed to have a proper vote by the board of directors or shareholders. And the ethical violations, conflict of interest, once again, it might be unconsentable, and a business transaction with the client. And that's it. That's a wrap. 2015, July, question 5. Thanks for listening.